I am Jeff Kravitz. I am the co-chair of the Beverly Hills Bar Association's ADR section, and we are thrilled today to be hosting Mr. David Hoffman. He is the John H. Watson Jr. Lecturer in Law at the Harvard Law School, where he teaches 3 classes, most notably with the topic of mediation. He is an attorney, a mediator, an arbitrator, and founding member of the Boston Law Group Collaborative, where he handles family, business, and employment and other disputes. He is the past chair of the ABA Committee on ADR and is a distinguished fellow of the International Association affiliated with ADR. It is with that abbreviated introduction that I introduce David, a graduate of the Harvard Law School, magna cum laude. Thank you, sir, for joining us here today. You have the floor.
Thank you. It's my pleasure to be here. Thank you for the lovely introduction. And I see there are about 100 people in the Zoom room, and I do know that some people watch this on recording, as I often listen to continuing education programs. So welcome, everybody, to this Zoom space. As you may know, you do have the opportunity to put questions in the Q&A if you have any, and I'll try to get to the questions before the hour is over. I usually start with New Yorker cartoons because I find that they are a nice window into some of the things that frame our talk, such as thinking outside the box. So I'm going to be presenting some ideas that might feel like they're a little bit outside the box. We in the mediation world, that's one of the superpowers that we aspire to is thinking outside the box, not only in terms of solutions, but also in terms of process. One other cartoon is about beginner's mind. So whenever we are learning something new, we aspire to the Buddhist concept of beginner's mind, clearing out, or at least asking the judgy parts of our minds to take a step back and create some spaciousness. As you may know from the materials in preparation for today's talk, I recently published a book with the American Bar Association called The Art of Impasse-Breaking in Mediation. And so I'm going to be sharing material with you today that is in the book. The book's available through the ABA and otherwise. Also, we're putting in the chat. Suzanne is helping us with that, and in the materials for this course, an excerpt from the book that you can have for free as part of this event. The agenda is that I want to talk about some process interventions, some substantive interventions to break impasse, and then open the floor for Q&A. Before doing that, however, I want to share with you 2 things that are not in the book. One of them is a story, mediation story. It'll probably be in the 2nd edition of the book whenever that happens. I'm also going to give you a quick case example because I think we can refer back to this case as I proceed through this 1-hour presentation. So let me start with a story, and this story is often referred to as the 18th camel. Some of you may know this story. It appears in Bill Urey's book, Getting Past No. He also did a TED Talk in which he talked about it. And the story goes back to the 18th century. I'll give you the source for it in a minute. But let's start with what is the story of the 18th camel? Well, it has to do with an inheritance dispute. The parents died, their adult children, there were 3 adult children, inherited from their parents. The will says that the oldest of the 3 gets half the estate, and the middle child gets 1/3 of the estate, and the youngest gets 1/9 of the estate. The problem, their estate consists of 17 camels. And if you try to divide 17 camels in half or 1/3 or 1/9, that just doesn't work. So the solution is, of course, they hire a mediator. So the mediator arrives riding her own camel, and she decides to donate her camel to the estate. So now the three siblings have 18 camels, and the math works just great because my slides just went completely berserk there. I'm not sure why. I think I have an overly sensitive touchpad or something. I got near the touchpad with my thumb and it went crazy. So they hire a mediator. The oldest now gets 9 camels. Half of 18 is 9, and the middle child gets a third, which is 6. And the youngest gets 1/9, which is 2 camels. Now, if you add up 9 and 6 and 2, you get 17 camels. And so the three siblings returned the mediator's camel to her, and everybody was happy. Now, if you're mathematically inclined, you might go to ChatGPT, as I did, to create a pie chart to see what the heck is going on with the 18th camel story. And what's going on is that if you divide up an estate, the whole circle is the estate, and give out a half and a third and a ninth, you haven't given out the whole estate. There's 1/18th, about 5.6% of the estate, that's not allocated under the will. And so the mediator figured out that if this surplus, this excess, that unallocated amount was allocated proportionally, the oldest child, instead of getting 50% of the estate, would get 52.9%. The middle child would get, instead of a third, 35.3%. And the youngest, instead of getting 11.1%, would get 11.8. So now all of the surplus has been distributed, and there's a camel left over. So the story of the 18th camel, you can read about it in Wikipedia. The source, the original source, is Mullah Muhammad Mahdi Naraki, who was an Iranian philosopher of the 18th century. Or you can click on Bill Urey's TED Talk called The Walk from No to Yes. And by the way, as you may know, the recording of this presentation will be available to you. So if you're worried about taking notes on all this, you don't need to worry. So the essence of the story of the 18th camel is when mediators come along, one of our tasks is to see if we can identify some surplus value. And it may be the reduction of transaction costs. It may be an apology or some other kind of emotional exchange. It might be figuring out that there's an absent stakeholder and we need to enlarge the number of people. We'll get to that topic in just a moment. But I said I would share with you a case study, and I will. So this was from about a week and a half ago, a very simple case, not a terribly high stakes case, an employment termination of a chief financial officer. Now I've changed the identifying information to protect everyone's confidentiality. The CFO was terminated, and the company that terminated him said they did it for cause, and therefore they didn't need to pay him severance. But the CFO said that their claim, the employer's claim of cause, was bogus, and he lawyered up, filed a suit with a make-whole demand of $321,000. And the company, claiming that the CFO had been negligent in his duties, filed a counterclaim. So they were seeking money, and we had a pre-mediation Zoom call with the lawyers. Mediation begins at 9:30 in the morning. And even though the plaintiff wanted to stick with their 321 number as their demand, by having a meeting among counsel, we determined they really needed to come up with a number that wasn't their grand slam home run number, but instead a lower number than that. And they proposed 250, and the defendant said, we'll drop our counterclaim and we'll pay $25,000. But they saw the plaintiff's case as being really bogus because they had very, very abundant evidence of the CFO's negligence, or so they said. And frankly, there wasn't that much debate about whether the CFO did a good job or not. That wasn't really the crux. The crux is whether they had crossed their T's and dotted their I's in terminating him for cause. And there was a good argument that they had failed to do that. So that's where the case rested. But the lawyers looked at these numbers and said, uh, we've got a big distance to travel. And so plaintiffs' counsel, I mentioned the possibility of range bargaining, and plaintiffs' counsel thought that was a good idea and said they'd be willing to drop from 250 to 175 if the defendant would come up to 100. And you can imagine the defendant wasn't willing to do that. They proposed their own range, which was they would come up from 25 to 40 if the plaintiff would come down to 120,000. Now, very often in mediations that I'm involved in, this range bargaining will continue right to the end. And what's happening is the bookends are getting closer, even though no one has accepted the other side's range. But in this case, the plaintiff decided to go back to a number, fixed number, and said, well, we'll come down from 175 to 160. And the defendant made what I thought was a non-trivial jump from 40 to 70. And so now the bookends are getting closer, but the parties started hitting the brakes. So now, and you'll see in a moment, we're going to reach a point of impasse because there's a move of 15,000 by the plaintiff, and then a movement of 10,000 by the defendant, and then a move of 7,500 by the plaintiff, and then a move of $5,000 by the defendant. And so now we have a significant settlement gap, 52,500, but each side is hitting the brakes. And it doesn't look like the trajectory of these ever reducing proposals those lines are not going to cross. And so at that point, the plaintiff suggested, how about a mediator's proposal? And I had told them that I'm willing to do it if that's what they think would be, if we all agree that that would be expedient. And the defendant said, sure, let's do that. Now, those of you who have a calculator handy can probably guess what my mediator's proposal was. I would say in most cases where I'm doing a mediator's proposal, it's not smack dab in the middle. First of all, I want to gauge what constraints each side is under. And here there were several, which I'll explain in a minute. But what I concluded in this case was that each side had reached a point of resistance. For example, the defendant said, we will never get to $100,000. And the plaintiff told me, this is all privately, said, we'll never go below $120,000. So I knew that there was a very significant gap. Each side was dug in. And I made a proposal privately to each side. That's how the process works. $112,250. And with it, I provided a case evaluation as to what I saw as the risk factors for each side in going forward to trial. And the ground rules for mediator's proposal are that each side responds privately and confidentially. And I don't report the response unless I have two yeses. But in this case, I did have two yeses. And so by 8:30 in the evening, we had written up a memorandum of understanding and signed it. Now, I mentioned that there were constraints. Well, the defendant felt like they didn't want to pay any money at all because when they fired the CFO, they did it exactly according to instructions from their previous law firm. And they felt that if they were going to have to pay a settlement to get out of this case, their law firm should pick up the tab. And so in the middle of the mediation, I'm on a speakerphone with the defendant and the defendant's CEO, and she was talking with the lawyer representing her former law firm, her company's former law firm, and trying to round up some money from them. So we had a stakeholder on the defendant's side and the insurer for the defendant's previous law firm. And on the plaintiff's side, we had a plaintiff's lawyer who was on a pure contingency. So he had a vested interest. And the plaintiff had used a litigation funding firm to keep him going while he was pursuing the litigation. So we had approximately 7 stakeholders in the case. And so that constrained this process a good deal. And it meant that when we reached this point of impasse, we had a very delicate question of how much movement would each side accept, and I concluded that I should find the exact midpoint, and in this particular case, that worked. What you see here in gray are the times when I had joint sessions with just the lawyers. I had only one joint session with the parties. There was no love lost here. The CEO didn't want to be in the same room with the terminated CFO, and I don't think he wanted to be in the same room with her. But we did have one joint session at the very beginning, 18 separate caucus shuttle diplomacy sessions, and four joint sessions with both attorneys together in my office. And I have found over the years this is one of the most useful impasse breaking techniques. If you don't think that a joint session with all hands on deck, all parties, all lawyers is going to be productive, and in many cases it's not, having a meeting, at least with the lawyers, turns out to be quite useful. Now, here's my secret sauce. I bring to in-person mediations. Most of my mediations are on Zoom, but when I meet in person, as I did in this case, I bring my dog Bella, because even though the parties may dislike each other, nobody dislikes a golden retriever in my experience. And so long as I check in advance to make sure that there are no dog allergies or dog phobias, and I haven't had that yet, I bring Bella along, and I have to say, Bella's batting average is extraordinary. She's batting 1,000. Every single case in which I've brought Bella to the mediation, and I only got her, right? She's a rescue from Serbia. I got her during the pandemic. And so I've only had her for a few years. But not only has she settled every single case that she's attended, but she works pro bono, if you catch my drift. So we always bring treats. People give her treats, and the oxytocin is flowing in both directions. I think that helps us settle the case. So with that as an introduction, the 18th camel, the case study, let's dive into some specific impasse breaking techniques, in addition to the ones that I just mentioned in the case study. And the premise for this discussion is that the mediator has already done the basics. The mediator has heard the parties' respective accounts of what happened, has explored their feelings about what happened, has elicited their underlying interests, has brainstormed options. And by the way, in the talk that follows, this is not just for mediators, it's also for lawyers who use mediation. So if you're counsel in a mediation, you want to make sure that the mediator has at least done all of these basics, including considering what's the alternative to a negotiated agreement. And getting to yes, the book Getting to Yes, this is often described as BATNA, your best alternative to a negotiated agreement. In litigation matters, which are the majority of what I mediate, I mediate some other kinds of cases too, business, family cases. But usually in my cases, you're going to court if you don't settle, and therefore the MALATNA, the most likely alternative to a negotiated agreement, is what's relevant. So all that's happened, and the parties are stuck. Now what? So the first thing to do, of course, is to diagnose the settlement barriers. Why hasn't the case settled? Is it some psychological or cognitive or emotional barrier? What is it? Well, it might be missing information. For example, in the case study I mentioned, we didn't know whether the plaintiff would be able to persuade the litigation funding firm to take a haircut. And sometimes I've had one case recently where a married couple who owned a business together, didn't know what their tax liabilities were going to be for the previous year, and they had a very complicated business. And that was a missing piece of information. So we had to hit the pause button in the mediation until we could fill in that puzzle piece. It might be missing people. I've had cases where a critical stakeholder was absent. And I'll give you an example from a family case where a couple was trying to stay together. And the husband, it was heterosexual marriage, the husband said, well, the real problem here is that my mother-in-law is bad-mouthing me all the time to my wife. And so I asked the wife, do you think your mom would be willing to participate in the mediation? And she said, yeah, probably, but I don't need to be here. It's between them. So I said, husband, how about a mediation session with just you and your mother-in-law? And he said, great. And so we found out that there's a particular bagel shop in Newton, Massachusetts that she particularly liked. And so we had our mediation session at the bagel shop. The bagels were terrific. And the mother-in-law and her son-in-law buried the hatchet, and the couple remains married, so far as I know. So we always have to do an assessment, even in a commercial, whether it's commercial case, family case, are there some stakeholders who are missing? Let's say everybody is on deck, so to speak. Everybody is in the mediation room, but there's some who don't get along very well with each other. So in one of my uh, commercial cases involving an ESOP, an employee stock ownership plan, the senior lawyers involved in the case couldn't stand each other. They didn't want to be in the same room. And the junior lawyers didn't really have enough gravitas or authority to settle the case. But each side had hired an expert witness who was very experienced, and the two experts knew each other. And at a certain point, it became clear that the two experts were going to be able to figure out a solution more readily than anybody else. So I always look, if there's an impasse, to see are there certain people who could have a more productive conversation than others. I mentioned Bella. She could be one of change the players and bring Bella in. She has a web page on the Boston Law Collaborative website where we talk about not only her willingness to work pro bono, but also some articles about dog-assisted mediation. It's a whole thing. What about partial settlements? So the parties are in an impasse, but there's some low-hanging fruit. Writing it up sometimes gives people hope. And so I find that coming up with a partial agreement often works. I don't know if you can hear in the background, but Bella is barking right now because she's guarding our house from, I think, a UPS driver. Um, Sometimes the parties could benefit from considering some other process, maybe arbitrating a portion of the case, or maybe bifurcating the case in some way and litigating part of it, or using some case evaluation, which we'll talk about in a moment. I have found that when the parties reach an impasse, sometimes it's helpful to take a step back and hear where the parties have come from. I remember one case in which there was a whistleblower who had been terminated, and the company thought that the ethical issues he raised were, not genuine, not a real source of concern. But he kept filing these ethics issues with this company. And so I asked him, because we were really at a standstill in negotiation, I asked him to tell me the story of his service in the Army. I saw in his resume he had been in the Army for 20 years, and then he retired and went into the corporate world. And he told me this very moving story about how in the Army, he was very proud of his Army service. He loved being in the Army, that everybody turned square corners because you had to. Your life depended on it. You had to rely on people to follow the rules and follow the chain of command and so forth. And as he was waxing poetic about his military service, I saw the light bulb go on over his head. And he said to me, I think I wound up in the wrong place. He said, in the corporate world, it seems like anything goes. I really liked being in the military much better. And so whether it's stories that parties share with each other, and I have found that that's often very useful, or just stories they tell the mediator, when people feel deeply heard and seen and understood by are paying careful attention to their stories, it can sometimes unlock an impasse because people are now emotionally better prepared to settle the case. Um, So, and if you can get even the lawyers may have humanizing stories to share. Um, and one other kind of story, which is really powerful in my experience, is the mediator telling stories of settlement. So if you've had a case similar to the one that's in front of you, but you're uncomfortable making a proposal, you're not sure how it will be received, sometimes explaining how you've seen other people resolve a similar case can provide what the social psychologists call social proof. In other words, other people have done this. Maybe it makes sense for you to do it. Identifying possible trades. So one side might have a concern about immediate money, the other might have a concern about long-term security, and they may be able to work out a deal that has certain contingent features in it. Um, if you're dividing a marital estate, maybe one of the spouses doesn't want the private equities because they're kind of risky and wants, the more secure stocks and bonds. And the other party really values the private equities because they have a lot of potential. And so in that kind of situation, both sides can be made better off. Instead of dividing the assets right down the middle, we give each party what they actually prefer. Metaphor is a really useful tool. Jose Ortega y Gasset said the metaphor is the most powerful tool known to humankind. And what you see on the screen is the image of a rearview mirror and a windshield in a car. And I sometimes say to people, in mediation, I often say this early on, it's like driving a car in terms of how we relate to the past. You wouldn't want to drive a car with no rear view mirror. So we are going to spend some time talking about the past. But if the rear view mirror was as big as the windshield, we never get anywhere. So our main focus is going to be the windshield, namely the future. Um, Another metaphor when people get frustrated is whitewater rafting. It may feel like we're in the middle of turbulence right now, but there are smoother passages. And if you stay in the boat, your river guide has been down this river before, and I think we can get this done. And in divorce cases, when the parties are squabbling about the kids, I sometimes use the metaphor of parents being the co-pilots in the plane. So you want to keep the cockpit door closed. You don't want them overhearing conversations on the intercom. So you make sure the intercom's turned off and just give them reassuring messages. And remember, the pilot and the co-pilot have to agree on the destination if the plane is going to be landed successfully. Food is often a great way to break an impasse. And I have found that getting the parties together for a meal, if we're stuck, it's very helpful to have a ground rule that says we're not going to talk about the case. Talk about anything else under the sun. And that ritual of eating together can sometimes help us resolve a case. When you're really stuck, remember what Mahatma Gandhi said, speak only when it improves upon the silence. Sometimes mediators need to just say, well, we seem to have reached an impasse. I wonder where we might go from here. And then just be comfortable sitting with the silence and see what people say. Taking a break can distract people from how frustrated they are with the other side. Eric Galton, who's a mediator in Texas, tells a great story of a CEO in a case, mediation case, being really stuck, and with permission of everybody, Eric asked the CEO if he'd like to take a walk around the lake in Austin, Texas, where Eric practices. CEO said sure, and they talked about everything under the sun, not that much about the case. They came back and they settled the case. Sometimes you need to step out of the fire in order to douse the fire. Apology can be a hugely powerful impasse breaking technique. But the question is how to tee up an apology. And what I've found is that often asking the question, if you could roll back the videotape, is there something you would do differently? So, for example, in the case study I shared earlier, the company probably would have been willing to say, it wouldn't have made a difference to the plaintiff as it happens, but could have said, yes, we wish that we had handled the termination differently. Those kinds of statements can be made in a mediation if confidentiality and privilege are protected because they'll be inadmissible. But even with those protections, people are often very uncomfortable apologizing. However, if you can tee up a mutual apology, for example, the CFO could have said, I wish I had handled some of my responsibilities differently than I did. I can sometimes tee up that mutual apology by asking each side if they'd be willing to share that with the other side, if the other side is also willing to apologize. Case evaluation. Now, in the case study, I mentioned that I did case evaluation. The reason I did it was the defendant wanted to be able to take that case evaluation to their old law firm and to the old law firm's malpractice carrier and counsel for the old law firm and say, we paid $112,250, and that was a reasonable settlement. So they want to protect their right to collect on their malpractice policy, on the law firm's malpractice policy, by refuting the argument that they overpaid to settle the case. That's not why case evaluation is usually used. Usually it's used to help the parties and the lawyers get a better sense of what's likely to happen if the case goes to trial. And when I do case evaluation, not always, but some of the time, I use a decision tree of the kind that you see here, where you where you predict what's the likely outcome of particular uncertainties in the case. This is an insurance case in which the potential recovery was $31 million. But because there was a 50-50 issue of timely notice, there was also a big issue, a 90-10 issue, in my judgment, about whether an exclusion applied, and also an issue about how the damages would be valued. This was a case where there was it was a manufacturer who suffered a loss because of theft. If you roll back all these uncertainties, the litigation, the settlement value of the case was $822,000. So these kinds of decision trees help the case evaluator explain the reason for their judgment, their prediction of what a court might do. Now, case evaluation is often done by retired judges. So if you're a mediator or if you're a lawyer in a mediation, you might want to bring in an outside person. But often the parties want the mediator's case evaluation. By the way, the American Bar Association recently issued Formal Opinion 518, which says that it's okay for a mediator to offer an opinion about what a tribunal is likely to do. But the lawyer, if you're a lawyer and therefore subject to the rules of legal ethics, you should not state or imply that a settlement is in a party's best interest, because that's up to their lawyer to give advice about. Now, your mileage may vary in other states. I don't know about California, but in Florida, there's a court rule that says the mediator should not offer case evaluation. So in that case, you might hire someone outside the mediation, like a retired judge. The use of hypothetical proposals. So I often will ask one side, if I can get the plaintiff down to 100, do you think that your side would come up to 100? And the answer might be yes or might be no, but it's useful to find out. I'm not asking them their bottom line. I'm asking them a question about a possibility. Or I might ask the plaintiff, if I can get the defendant up to $100,000, do you think you would be willing to settle? Now, I actually did ask questions like that in my case study case, and both sides said no. Well, that's okay. That's useful data but sometimes the answer is yes, and then the mediator has information that can help settle the case. In Massachusetts, we had a judge named Joseph Toro, a great judge, passed away not too long ago. He was in the federal district court, and I watched him do this. I learned this technique from him. he would ask each side to write down on a piece of paper their absolute last best offer and provide it to the judge confidentially. And he would do this even in a bench trial situation, and of course also in jury trials. And after he looked at each side's confidential last best offer, he would then tell them whether they should, we should schedule a trial or instead go out in the hall and see if you can settle it. I have found that when I use this technique, after writing down the last best offer, the lawyers will very often say something like the following: I'll show you mine if you show me yours. And when they open up those pieces of paper, now the bookends have moved very dramatically closer together. Um, and now we get to Mediator's proposal. So I want to dwell on this for a minute because it's a very useful technique, not only in international diplomacy, as you can see with President Carter after the Camp David talks, but it's extremely useful in commercial and even family and employment and other kinds of cases. So, as a definition, case evaluation is a prediction of what the court will do. Mediator's proposal is a prediction of what the parties will do. And the ground rules, and I'm guessing many people, if not most in the Zoom room, are familiar with these ground rules, but I think it's worth mentioning them. Um, the mediator, first of all parties must want the mediator's proposal. And as a mediator, I ask the parties what else should be in it. So, for example, in the mediator's proposal that I made in the case study, there were bullet points for non-disparagement, confidentiality of the settlement terms. There was already in the employment agreement a durable obligation of non-solicitation and non-disclosure of proprietary information. There was going to be a stipulation of dismissal without prejudice and no admission of liability. Those were the non-monetary terms. Oh, and also that the tax treatment would be ordinary income, except the money going directly to counsel. So all that was settled. All I had to do was fill in the blank, which was the number. So I make the same proposal. In this case, I did it in writing. I printed it out, brought it into both rooms, and I asked the parties not to respond right away while I was in the room. I wanted them to have a chance to talk about it because when I went in the other room, I wanted to be able to say, I don't know how the other side is going to respond. And after each side's ready, they send me a text message and I come back into the conference room. They've had a chance to think about it. When I come back, they tell me either yes or no. And sometimes they come back and they say, no, but that's still a no. Although the but, if they say no, but we would be willing to do X, very useful information. I'm going to keep that to myself. So I report if there are two yeses. Now, what I've found is that in 80% of the cases that I do, there are two yeses. In 10% of the cases, there's a yes and a no. And in another 10%, it's getting lower nowadays. It might be closer to 5%, but in 5 to 10%, there are two no's. Those are the cases that are really hard to settle. The ones where there's a yes and a no, those cases almost always settle because the party that said yes is usually willing to disclose that. So I won't, okay, I will give you a sample case for Media's proposal. The plaintiff has demanded $6.5 million. The defendant has offered $250,000. And by the end of the day, the parties are stuck at $2 million and $1 million. And they want a mediator's proposal. So I show them these slides actually, and I did in the case study I mentioned earlier. And what the slides do is they illustrate how does a mediator decide what the proposal is. So I explain that I know 100% certainty that the plaintiff would settle at $2 million. And I know with 100% certainty that the defendant would be willing to settle at $1 million. I also know that there's zero chance that the defendant would settle at 2 million and 0% chance that the plaintiff would settle at 1 million. So between the poles of 1 million here and 2 million here, where do these lines of resistance cross? Where is the spot where if you go to the left or you go to the right, you're reducing the overall chance of a settlement? And the answer to that question might be smack dab in the middle, as it was in the case study, but it's not always. It might be over here closer to the defendant. It might be over here closer to the plaintiff. We just don't know. And indeed, there might be no zone of possible agreement at all. So I show people these slides and say, this is how I do it. I try to discern where is the crossover point. And in this hypothetical case, let's say I proposed $1.4 million. I thought that's where the lines cross. And let's say the case settled. We're in the home stretch here, and then I'm going to open the floor for Q&A. So range bargaining, I illustrated that earlier with the case study. It's basically parties proposing a range instead of a number. Contingencies can be our friend. Plan A or plan B. And that could happen in the case of an earnout. For example, let's say the CFO, actually the CFO had some stock in the company, and we didn't actually negotiate any resolution of that. He left with stock in hand. But we could have had a contingency that would have involved some profit sharing or earnout based on the shares, and he would have relinquished the shares. If there's concern about liability, for example, if the company's afraid they're going to get sued for some of the mistakes the CFO made, there could be indemnification. That would be a contingency. There could be tax sharing if there's uncertainty as to how a settlement will be taxed. Sometimes in cases where a property or a business is being purchased, there might be an inspection or financing contingency or an appraisal contingency. Or if somebody wants to buy back the business or real estate, there might be a right of first refusal. Dual or multiple offers. So this is one of my favorites, actually. Let's say the plaintiff coming in my case study at 250,000 is concerned that the defendant will experience sticker shock. What the plaintiff can do is say, I'll tell you what, if you accept 250 as a settlement, that's fine. But if not, we're willing to share in the cost of an external case evaluation, retired judge, because we believe that the fair and reasonable value of the case is 250. And generally, the other side rejects the both prongs of the dual offer, either 250 or case evaluation. But it adds credibility for one side or the other to say we're willing to do either one, non-binding case evaluation or our number. Sometimes when both parties want a piece of real estate or other belongings, an auction can be useful. And it could either be an internal auction or the property or business can be put on the market. When it's put on the market, you're going to get higher value, usually. In an internal auction, you've protected confidentiality and privacy, but maybe limited the amount of money available for the purpose of the purchase. And then there's this really cool technique. If anyone in the Zoom room does matrimonial work, maybe you even use this. It's called the adjusted winner auction. So each side, each spouse picks out, you list the items, and each side has a bidding sheet. And they do this privately, separately. And let's say there's a piano and a painting and some other items. And so spouse A really values the piano and is willing to pay $5,000 for it. Spouse B doesn't really care that much about the piano, but knows that it has some value. So they put on their bidding sheet $2,000. And I've had cases where they had 20, 30, 40 items in the adjusted winner auction sheet. And the cool thing about the process is that the higher bidder gets the item, but gets it at the average of the two prices. So spouse A who wants the piano is getting it for 3,500 and they think they got a deal, whereas spouse B is going to get half the value of that 3,500, which is more than they thought they would get because they thought the piano was only worth 2,000. Joint experts and appraisals. So when the parties are stuck at impasse over the value of a business, real estate, or other property, often we talk about getting a non-binding appraisal, but there are disadvantages to that because people want finality. So I've come up with this three appraisal protocol, three-step protocol that has worked every time. And the way it works is the parties jointly hire an appraiser and they agree in advance they're not going to privately lobby the appraiser. All communications will be in writing, no ex parte communications. And after they get this non-binding joint appraisal, they negotiate and maybe they agree on the value. But if they don't, they jointly hire a second appraiser and then they negotiate and see if they can arrive at a value. And if they can't, then they go to step three, where they jointly hire a third appraiser, and then they're done because they've signed an agreement that the value of the property will be the average of the three, and they're bound by it. And I've only had one case where the parties ever got to step three because, for the most part, they don't want the decision taken out of their hands. Also, we have a provision that says if any one of the three appraisals is an outlier, meaning, let's say, more than 15% different from the average of the other two, we ignore the outlier, average the other two, and that's binding. And because it's mathematically possible that there are two outliers, the parties will reject the appraisal that's more of an outlier than the other and average the other two. Um, so there are many other parts of this book. You will have in your materials the heart of the book, but these are some of the other parts, the ones I listed on the screen. And with that, I'm going to stop the screen share because we have about 13 minutes, and I want to open the floor for any questions. I'm going to look in the chat and see if there are any, or Suzanne, if you have any
Yeah.
questions, please
Okay.
let me know.
Yeah, so we do have some questions in the Q&A. One is mentioning another mediator who thinks that mediator proposals are problematic because they necessarily favor one side and demonstrate bias. There was an article on that other speaker wrote. What do you think on that? Does AB Op 518 prohibit mediators' proposals?
Yeah, I know the article, Jeff Kitchaven, and Jeff is a good friend, and I have enormous respect for Jeff. I disagree with him about this, and there's a lot. If anyone wants to Google ABA Formal Opinion 518 and put Jeff's name in there, you'll find that there's a robust discussion online. And I think there's nothing, first of all, there's nothing unethical about doing case evaluation. And if you say to the parties in advance, you ask them, do you want a mediator's proposal? And they say yes. Then what you say to them is, okay, mediator's proposal is different from case evaluation. I'm not predicting what the court will do. I'm predicting where the point of resistance in settlement is for each side, because I've had private discussions with each side. And I could be wrong. It happens. Um, uh, but I'm going to give you my best guess of where there's a zone of possible agreement. And it might be over here. It might be over here. It might be in the middle. And I'm not going to tell you because the ABA opinion says lawyer mediators shouldn't tell you that it's in your best interest. So I'm not going to tell you that. I'm simply going to tell you where I think the two sides might be willing to settle, whether I think it's in your best interest or not. And if it works, then my prediction was accurate. If it didn't work, then let's go back to the bargaining table and see if we can get this done. So, Jeff, if you're out there listening, I welcome the chance to talk with you about this sometime. And whoever asked the question, thank you. Great question.
Alrighty, I have another question here. Do you think it is appropriate for parties to characterize a settlement as ordinary income, essentially giving them a tax win, which may or may not be appropriate? Okay. Usually my agreements have no characterization and no tax advice. However, the party can characterize how they want without the defendant's assistance.
Well, that's an interesting point. Um, I think that the question arises, it arises a lot in the employment arena because everybody's got the IRS and the Department of, or the State Department of Revenue or the Labor Department, potentially looking over their shoulder. And so I think the important thing is that both sides are, uh, you know, in agreement about the characterization, so they're not creating audit risk, for each side. I don't think there's anything unethical. In fact, I think it's quite sound practice for the parties to talk about that. Um, and in my experience, I can't think of a single case where the parties didn't reach agreement on that point. And it may be part of the question that you just read, Suzanne, that the parties, it's not my job to police, as a mediator, to police how the parties characterize settlement money. And I'm not a tax expert, and it's not my place to give them advice about how the IRS or State Department of Revenue might look at it. My job is simply to help people not only resolve the present conflict, but hopefully avoid future issues. And that's why I have that discussion with them. And every now and then there's a tax issue so complicated that it's worth bringing in an outside opinion about it, where each side might get their own tax opinion. Um, and I guess there's a related question. If someone tells me, well, I'm not going to report this income, am I colluding in some way by keeping confidential what, let's say the party, this has never happened to me, but let's say the party said, yeah, I know this is taxable income, taxable under either ordinary income or some other heading, but I'm not planning to pay taxes on it. I would be very uncomfortable writing up the agreement under those circumstances because it would feel like I'm colluding in tax fraud. So I might, withdraw at that point, although my withdrawal may be inconsequential because maybe the parties have now figured out how to settle this on their own. So sorry to give such a long-winded answer to a very straightforward question, but it seemed to me like there were several elements in it.
Great, thank you. And let's see, I have one who asked, in the adjusted accusation, what happens when both bid the same amount?
Okay. So there is with confidential last offers, there are three possibilities. There's a gap. They pick the same number, or their numbers actually overlap. And so what I usually tell people in advance is if their numbers overlap, I'm going to recommend a settlement at the average of the two numbers. That's only happened once in my memory, and I've been mediating now for 34 years. Usually there's a gap. If the parties pick the same number, that's easy. I just report that we have a settlement. But Suzanne, I'm not sure if the question I answered is precisely the one that was being asked. Can you read that one more time?
Yeah, of course. In the adjusted accusation, what happens when
Oh,
both bid the same
ah,
amount?
the adjusted winner auction. I answered a question that wasn't even asked. So in the adjusted winner auction, we have a protocol that the that their bid needs to be either an odd number or an even number. So even if it's like $5,001, the other person offers 5,000 or something like that. By saying that it has to be either an odd number or an even number, you never get a tie.
Great, thank you. And let's see. So Christopher Daniels is asking, what do you do when the impasse on a settlement, in this case, business litigation, is not the monetary terms, but non-monetary terms where the plaintiff is insisting on non-monetary terms that it could not get at trial?
Great question. So, that is the case in, a significant number of commercial mediations, and it may be, for example, release from a non-compete agreement, or the imposition of a non-compete agreement. And neither of those is going to be available at trial. So now we have a business negotiation going on. What are the interests here? How can those interests be met? And we look at the various contingencies and so forth. And if there's truly an impasse, then part of the analysis is, okay, well, let's say we don't have an agreement. What is going to happen? And sometimes that, gets the creative juices flowing because the non-agreement alternative doesn't look so great. But I also just want to acknowledge that there are some cases that don't settle for a reason, because there's a good faith disagreement about the value of the case, or there may be certain constraints that the parties can't do anything about. It may be a bet the company case, where settlement just isn't possible because the one side doesn't have enough money to satisfy the other side, and so they have to go to trial. And but I think the important thing is the mediator meeting separately with each side can explore very thoughtfully options and alternatives. Options are what's available at the table. Alternatives are what's available away from the table, namely in court, or if it's a commercial transaction, is there some other party that they could do the deal with? I want to say one more point on this, which is that there's a great metaphor that Bob Mnookin and his co-authors came up with in the book Beyond Winning. And it's the idea of bargaining at two different tables. And in mediation, this happens all the time. One table is the table of expected value. What's going to happen in court if we don't settle? And lawyers are very ready to, argue and discuss at that table. The other table is the table of interest-based bargaining. How can we make both sides better off? And sometimes people get very frustrated at the table of expected value because they disagree about the settlement, about the case evaluation. So they go to the interest-based table. And if they get frustrated there because they haven't come up with an interest-based option that works for everybody, they go back and forth. And over time, after exploring the disagreement here and the challenges here, they decide, you know what? I think we're going to have to move off of our positions to come up with a solution. So part of my job as a mediator is to sort of normalize the fact that there are two, often at least two, sometimes more than two conversations. I guess there's a third table where people talk about if there are emotions in the case, is there some kind of emotional exchange, some kind of relationship repair, or just, the storytelling or apology that might help people at that third table. So I see we have a minute, but I'm willing to go beyond if there are more questions. Suzanne, is there anything else in the Q&A?
You have a few questions, actually. We have about 3 or so. Let's see. So John is asking, on any settlement, the tax man is a silent partner, and I'm guessing P's want W-2 payroll payment as low as possible, and D's want a reasonable value to avoid tax issues when P's do not have the funds to pay their taxes on April 15th.
Right.
Plaintiff, defendant,
Plaintiff.
silly. Okay.
Yes.
Yeah.
P&D, plaintiff's and defense.
Yeah.
There's in the cases where I'm the mediator, there are often discussions about this. And the tax laws have changed a bit. This is mentioned in the book, The Art of Impasse-Breaking, to make it harder to, in employment cases, to uh, allocate part of the settlement to non-wage income. But it's not impossible. And what often happens is the defendants, the employers in those cases, want an indemnification from the plaintiff because if the IRS or the State Department of Revenue comes around saying to the employer, you didn't, you characterized this settlement in a way that's not supportable, and you're going to owe some Social Security or other funds, the plaintiff will often provide that indemnification in exchange for a characterization of the allocation between ordinary income and 1099 income. But many employment plaintiffs are not willing to provide such an indemnification. And so, as I mentioned earlier, I've had cases where we bring in an outside tax expert, and often that's quite useful in figuring out what is a reasonable, defensible position to take on allocation for tax purposes.
Great, thank you so much. And let's see, I have another one from Erica asking, how do you assist the parties in settling a matter when one lawyer on the or the other's behavior is creating the obstacle to settlement and the lawyer doesn't appear to be open to discussion about his or her behavior?
Mm. Uh, I certainly have had situations where that's the case. And I mentioned earlier sometimes changing the players and figuring out who can have a productive conversation. Um, but one of the things that I do when I'm dealing with could be a party, but or it could be a lawyer who's being very difficult. I say, well, okay, I get you have strongly held views. What's your proposal? They tell me their proposal. I say, well, what do you think the chances are the other side will respond to that proposal as opposed to leaving the negotiation? And very often I find that they are making a realistic determination of how the other side might react. And if it's, well, I think there's a good chance the other side will walk, then okay, well, maybe a different proposal would be useful. Or sometimes they're overly optimistic, and I say, well, here's my prediction. I think with that proposal that you want to make, they're going to experience that as I think there's better than a 50% chance they'll walk. That's my hunch. I don't know because we haven't presented that yet. So basically what I try to do is to get them in off the ledge, so to speak, by doing some reality testing about how the other side might react to what they want to do.
Great. So it looks like we just have one question here. Any suggestions for when the impasse is emotional, non-rational, in addition to the ones you've mentioned? Or when the parties can't seem to agree on non-economic facts in a way that interferes with reaching agreement?
Yeah, so I think part of our job as mediators is to bring all the tools of psychology that we can learn about to bear on the situation. And that doesn't mean we're providing psychotherapy. We're clearly not doing that. But what I have found is that sometimes I can tee up an emotional exchange that will be useful. And sometimes I can help people manage their own strong feelings of ambivalence about settlement. And I'll tell one quick story of each of those two kinds of emotional situations. So the first one involves an uncle and his niece. The uncle had just lost his sister to cancer, and that's the niece's mother. So they were both grieving. But this case came to me about 3 years after the sister, the mother had died, and the uncle, who was a lawyer, had badly mismanaged his sister's estate. It had taken 3 years for the niece to finally get his attention. And the way she got his attention was by filing a lawsuit to get him to complete the estate. And he apologized right at the beginning for how badly he'd handled the estate, but the apology didn't really move the needle. Bargaining back and forth, getting some numbers on the table, we finally got a settlement. But what the uncle really wanted, beyond figuring out a financial settlement, was he wanted forgiveness. And he wanted to be family again. And so with permission of the lawyers, I met with just the uncle and the niece in my office. And there was one other thing he wanted, which was he wanted the niece to agree that she wouldn't report him to the Board of Bar Overseers, because having his license was critical to his making a living and supporting his family. But you can't put in an agreement, an enforceable agreement, a provision that says that you won't go to a public official and report misconduct by a lawyer. So that never became part of the negotiation, even though the other side, the niece's side, knew that's what the uncle wanted. And so in my office, the uncle said to the niece, "I'm really glad we figured out the money solution." But he said, "What really matters to me most is, can we be family again? Celebrate holidays together. And what I really want to know is if you're willing to," and he was just about to say the word forgive, and the niece held up her hand like this. And I thought, oh dear, this is not going to go well. And she said, "I've already forgiven you. In my heart, I've already forgiven you." And he got very teary. And then she got very teary, and they gave each other a hug. And so, then they each gave me a hug. And she said, and by the way, "I'm not going to report you to the Board of Bar Overseers." And he was so relieved, and he gave her another hug. And those kinds of non-monetary and in some cases, non-negotiable terms can make a huge difference. Now, the second and last case I want to mention involved a woman who was a manager, a high-level manager in a company, who was laid off. And she claimed sex discrimination. She had a very good lawyer. She had a very good argument of sex discrimination because the company replaced her with a man and gave him the same job duties, but just changed the title. So she had a pretty good case, but it would have taken years. And she was the primary earner in her family. And so I sat with her at the end of the day. There was $250,000 on the table. And she was really struggling internally, emotionally, with whether to take $250,000 and move on, or fight the good fight for women's rights and women's equality. And she felt very strongly about both of those things. So I sat with her and I said, I mentioned that I've been studying the internal family systems model, and in that model, it posits that we all have different parts, internal parts of us. And it sounds like there's a part of you that wants to fight the good fight, to make sure that other women aren't subjected to sex discrimination. And she said, yes, very much so. And I said, and also a part of you that's very concerned about making a living, because you're the primary earner in her family and you need to be able to make your mortgage payments. And she said, absolutely. I said, in this IFS model, there's this idea that we all have a mediator inside us, what we call self-energy. And that mediator can listen to these two different parts and mediate a resolution that you can accept and maybe even embrace as a reasonable resolution. I wonder if you can feel that internal mediator in you. And she paused, and I could see, she was really consulting her internal mediator. And then she looked up and she said, "I know I need to settle this and move on." And and with that, we reached a resolution of the case. And I was meeting with just her and her lawyer, and uh, she stood up and her lawyer stood up. They gave each other a hug, and so there are a lot of when mediations end on a very happy note, there's often hugging involved, sometimes tears. I would say most cases aren't emotional in quite that way, but in every case that I've been involved in, psychology, emotion is part of the mix. And part of my job is to be attentive to not only the words, but the music. Not only what people are saying, but what are the feelings behind what they're saying. And so with that, I think we're going to bring, Suzanne, are there any other questions? Because if not, we'll bring today's session to
Do
an end.
actually have one last question.
Okay.
It was, have you ever used AI as a tool to assist in resolving impasses?
Great question, very timely question. So I've started using AI to look at option generation, but I have not yet introduced it into the mediation room. I'm not sure that the lawyers and the parties that I work with would be entirely comfortable with that as a tool. And of course, there's concern about when you put in the question, when you put in the facts of a case, have you properly disguised the information so that you're protecting the confidentiality of all concerned? So I have no doubt that the time will come when we'll be using it. And in fact, in my book, there are 60 impasse breaking techniques listed. And one of the 60 is using AI for option generation, because it's certainly something we ought to be thinking about as a possibility. And I don't think it'll be long before we're using it on a regular basis.
Great, thank you. So that looks like that's the last of the questions today. Thank you so much, Mr. Hoffman, for an excellent presentation, and thank you so much to our audience today. Have a great day, everybody.
Thank you.